Jonathan Lee Riches Investigates. I am covering the tragedy out of Moscow, Idaho. Let's talk about Bryan Kohberger's preliminary hearing. As of now, his preliminary hearing is scheduled for June 26, 2023, Latol County Courthouse in Idaho. But it's quite possible that Bryan Kohberger and his defense team, and Taylor, his public defender appointed to him, waives that preliminary hearing. And I'm going to explain a little bit about waiving a preliminary hearing, because it is possible. It is possible. There is pros and cons to a waiving of a preliminary hearing. It can work beneficial for the defense, and it also can work beneficial for the prosecutor if the defendant and the prosecutor come up with an agreement to waive a preliminary hearing, or no agreement. The defense can just say they want to waive it. And I want to show you something right here. Check it out. So I found this site, and this is the best in-depth analysis about preliminary hearings I want to share with you. What are the advantages and disadvantages of waiving a preliminary hearing? In some felony cases, it may be beneficial for the accused to waive the preliminary hearing. Although unusual, some reasons to give up the right to preliminary hearing examination include: it avoids preserving testimony of witnesses, especially reluctant ones. Bail status might be affected if evidence shows the crime to be aggravated. It locks in charges and avoids evidence of offenses not in the complaint. There are also many reasons not to waive the preliminary hearing. In some cases, the examination will reveal defenses that were not readily apparent, reveal witnesses who do a poor job testifying. Would that be Dylan Mortensen? Possibly. Show the prosecutor there are problems with the case. To give up the right to a hearing, the accused must expressly waive the right to a hearing, be represented by an attorney. What are the disadvantages of waiving a preliminary hearing? The accused has a substantial right at the preliminary hearing. The hearing may be the only time in a felony case that evidence is taken. Confront prosecution witnesses, present evidence at the hearing to negate an element of offense, impeach prosecution evidence, or establish an affirmative defense. Evidence helpful for an accused can convince the prosecutor a negotiated settlement is justified. It is not unusual for a preliminary hearing to reveal defenses that were not readily apparent, reveal witnesses who do a poor job of testimony, show the prosecutor there are problems with important elements of the case. So there you go. And what is a preliminary hearing? A preliminary hearing is examination of the evidence in a felony case to determine whether a crime has been committed, whether there is sufficient cause to believe the accused committed it. Sufficient cause means that after hearing the evidence, a person of ordinary caution would have a strong suspicion of guilt of the accused. The overriding purpose of a preliminary hearing is to weed out groundless or unsupported charges. At the hearing, a qualified law enforcement officer can testify to hearsay. Hearsay is out of the court statement made by someone. The victim and other witnesses often do not testify. Defense witnesses are only allowed to testify if their testimony will establish affirmative defense, negate an element of a crime charge, and impeach the testimony of statements or of the prosecution witness. What are some of the goals at the hearing? The prosecuting objective at the preliminary hearing is to establish sufficient cause. At the same time, he or she will try to present as little of their case as possible. Some of the goals of the defense attorney at the preliminary hearing will be to build a foundation to impeach the prosecution's witness, to evaluate a witness testimony, to provide a basis for plea negotiations, to evaluate the strengths and weaknesses of the case. Even if the accused plans to plead guilty, conducting a preliminary hearing may highlight defenses that were not apparent before the hearing, reveal witnesses who do not hold up well under cross-examination, or demonstrate to the prosecutor the case is weak. So, a lot of options on the table when it comes to Bryan Kohberger. His defense lawyer, Ann Taylor, could work a deal out with the prosecutor and say, we will waive the preliminary hearing, meaning you can carry over the 4 counts of first-degree murder and the burglary counts. In return, you drop the death penalty. You drop the death penalty. That is quite possible. You wheel and deal when it comes to a preliminary hearing. You could go to the prosecutor and say, I want these certain charges dropped. And in return, we'll waive the preliminary hearing and we'll take it to court. And we'll take it up to the district court or county court, wherever, different states have different types of courts, superior court, common pleas court, and, let it go through the process on that level. But waiving a preliminary hearing is definitely possible in this case. And it can go all the way up to the day before, Bryan has all the way up to the day before the court hearing. Actually, he has all the way up to minutes before the preliminary to say, hey, we're waiving it. And they could just waive it because they don't want to, go through that process and they don't want to reveal their cards. The prosecutor at a preliminary hearing gotta, lay some things out. So sometimes they don't want to show their cards. So they are willing to work with the defense or hoping the defense wants to waive a preliminary hearing. So we'll see. As of now, he has one scheduled, June 26, 2023. Will it be that day? Remains to be seen. Subscribe to my channel, hit the notification button. Let me know what you think about preliminary hearings. Do you know about the law? Can you share a little bit about an insight? Was I wrong on anything I said? Enlighten us, please. I love to see your comments. We'll talk soon. Everyone be safe. Justice for the victims and their family. Oh, and one more thing I forgot to mention. The big thing. The testimony of Dylan Mortensen. If Bryan wants the preliminary hearing, he's going to hear the testimony most likely of Dylan Mortensen, revealing what she knows, a strategy. Maybe the prosecution wants Bryan to waive the preliminary hearing so they don't have to bring Dylan Mortensen forward around that time, because it's most likely that Dylan Mortensen is going to testify against Bryan Kohberger. Does the prosecution want Dylan Mortensen to testify at the preliminary so the defense can poke holes and catch her in discrepancies so they could use that against her when it eventually goes to trial? And most likely the case will go to trial. Another thing too is, there is a chance for Bryan Kohberger to have his charges all dropped at the preliminary. The judge can say, hey, there's not enough evidence, for it to go forward. But chances of that is like zero. But it is possible. It does happen. Or some charges get dropped. Maybe the burglary charge. Let me know what you think. Dylan Mortensen testifying. Is that a good thing or bad thing at the preliminary hearing? So both parties here can strategize here what they want to do here, and prosecution sometimes wants defendants to waive their preliminary hearing so they don't put their star witness on the stand. We'll talk soon.